Hello guys. In our last video we had discussed the changes brought under BNSS in chapter number 13, and so today we'll discuss the changes that are brought under further chapters. So let us begin our discussion for today with chapter number 14, which talks about the jurisdiction of criminal courts in inquiries and trials. The very first section that we'll be dealing with is section 202, uh, which deals with offences committed by means of electronic communications, letters, etc. If we go through this very section in the Bare Act, we'll notice the only minor change that is brought here. Uh, Kindly go through section 202, clause 1. The very first line reads as, any offence which includes cheating may, if the deception is practiced by means of electronic communications or letters or telecommunication messages, and the section goes on. But for all of our intents and purposes, what is important is that the phrase by means of electronic communication has been added. All right, so kindly underline that very provision, that very phrase, and try to memorize it and remember it. The next section that we'll talk about is section 208. It talks about offences committed outside India. Okay, so for offences committed outside India, uh, any person who had committed an offence outside India, he could be dealt with in respect of such offences as if such offence was committed within the confines of India. This provision was already provided for under CrPC. A mere addition, a new addition which is done under BNSS is that uh, along with the place where he may be found, he could also be dealt with at the place where the offence is registered in India. So kindly underline the phrase where the offence is registered in India, and so this is the new addition under section 208. Now we'll talk about section 209, which is a very minor, which brings forth a very minor change in this regard. This section provides for the receipt of evidence relating to offences committed outside India, and in this case, such evidences could either be in physical form or in electronic form. So this or in electronic form has been added. Moving on, the next chapter that we'll discuss is chapter number 15. It talks about the conditions requisite for initiation of proceedings. So the very first section, which is section 210, it provides for the cognizance of offences by magistrates. Here as well, the three modes via which magistrate could take cognizance of offence have been provided, but certain tweaks have been made. So if we go through section 210 clause 1 subclause A, which goes as, upon receiving a complaint of facts including any complaint filed by a person authorized under any special law which constitutes such offence. So we see that the phrase a person authorized under any special law, it is a new addition. But does it mean that under CrPC we could not, or the magistrates could not take cognizance if the complaint was provided by some person who was authorized under special law? The evident answer is no. All right. Of course, under CrPC, cognizance could have been taken, but there was no written law as such. So BNSS addresses this issue, and it has been included in the letter of the law itself. All right. So now we'll see section 210 clause 1 subclause B, which goes as, upon a police report submitted in any mode including electronic mode of such facts. So here the police report, of course, when we were discussing chapter number 13, we have seen that police report could be made under The information could be received in electronic form. Any data could be made available in the electronic form. So uh, why not police reports? So even when police report is submitted in electronic mode, there as well the magistrate can take cognizance. So the only change under this section are these two, that the phrase persons authorized under any special law has been added under section 210 clause 1 subclause A, and including electronic mode, it is included in clause B. Now let us move on to section 215, which provides for prosecution for contempt of lawful authority of public servants for offences against public justice and for the offences relating to documents given in evidence. Uh, this could sound as a very long and complicated type of section, but if we actually go through the provisions, we'll find that no such complicated issue exists. So let me break it down for all you guys. What changes have been brought under section 215 clause 1 subclause A is that simply a phrase has been added. If you go through this clause, you'll find that a phrase has been added: or some other public servant who is authorized by the concerned public servant so to do. This phrase has been added. What does it mean? Now, if we try to understand it in common parlance, in simpler language, it simply means that if any offense which is punishable under section 206 to 223, barring section 209 of the Bharatiya Nyaya Sanhita, then or of any of its abetment or attempt or criminal conspiracy that goes on with the section, then no cognizance shall be taken except upon a complaint in writing. Then who are the persons who could make complaint in writing? The first one is the public servant who is concerned. The second one is or of some other public servant to whom he is administratively subordinate. So these two guys were already talked of under CrPC. Merely a third person is also provided for under BNSS, that some other public servant who is authorized by the concerned public servant so to do. So now cognizance can be taken after noticing that a complaint has been filed by any of these three persons. Either the public servant concerned provides a complaint in writing, or any of the officer to whom such concerned public servant is subordinate, or any other any other public servant or some other public servant who is authorized by the concerned public servant so to do. So this is the only change in the section 215 clause 1 subclause A. Now let us look at section 218, which talks about the prosecution of judges and public servants. Okay, this section becomes very important for your preliminary examinations, because you'll see that under section 218 clause 1 second proviso. Okay, open the Bare Acts and go through the same. Section 218 clause 1 second proviso. All right, you'll see that provided further that such government shall take a decision within a period of 120 days from the date of receipt of the request for sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded by such government. So we have witnessed that throughout the entire BNSS, time periods have been introduced so as to facilitate effective carrying out of procedure and timely carrying out of procedure. In this very regard, yet another time limit has been introduced, and it is under section 218, that for any for any instances of prosecution of judges or public servants, you'll have to seek a sanction from the government, but this sanction must be provided in a section 120 days. All right, and if for that period of 120 days the sanction is not granted, then it shall be deemed that the sanction has been granted. Okay, so this is a very interesting provision, and all the more important if we talk about any of the preliminary examinations. All right. The next change is under section 219, which talks about the prosecution for offences against marriages. So the general rule goes as that no court shall take cognizance until and unless the person who is aggrieved by that offense uh, makes a complaint about the same. However, when we notice clause A to the proviso, where the changes have been brought, which goes as where such person is a child or is of unsound mind or is having intellectual disability requiring higher support needs or is from sickness or infirmity unable to make a complaint or is a woman who, according to the local customs and manners, ought not to be compelled to appear in public, some other person may, with the leave of the court, make a complaint on his or her behalf. So, the issue regarding the Pardanashi women was provided for under CrPC, but in case that person is a child or is a person of unsound mind or is a person who is sick or infirm and any person with intellectual disability requiring higher support needs, all these have been the new additions under BNSS. Then in all these instances, any other person apart from the person who has been affected by who has been aggrieved by the offense under sections 81 to 84 of BNS would be allowed to file a complaint on behalf of such persons. All right, so this is the mere change brought under section 219. And quite similar to this very provision, if we go through the next change that is under section 222, we'll note that more or less the very same changes have been brought under section 222 as well. It talks about section 222 talks about prosecution for defamation. There as well, the general rule dictates that complaint could be filed or it could be made by any person who was aggrieved by the offense. But the proviso similarly provides that if any person is a child or is a person of unsound mind, is sick or infirm, Pardanashi woman, or any person having intellectual disability, then in all these instances, some other person with the leave of the court could be allowed to make a complaint on his or her behalf. So the basic difference between 219 and 222 that is to be noted here is that in case of 219, we had seen that intellectual disability requiring higher support needs was the phrase which was used. But in case of 222, uh, the phrase used is person having intellectual disability, and that's all. Not a person of intellectual disability requiring higher support needs. Okay, so this is the difference between 219 and 222 in the terms of letter of the law. Besides them being quite different provisions. All right, so that's it for the changes brought forth under section 219 and 222. Now we'll talk about chapter number 16, that is complaints to magistrates. And under this provision, the very first change that is brought under, the very first change is brought under section 223 itself. 223 talks about examination of complainants. Right. Uh, Earlier under CrPC, merely the magistrate was required to merely hear the complainant and then he could decide what to do with the complaint. All right, but now it has been made kind of mandatory that no cognizance could be taken without giving the accused an opportunity of being heard. All right, so under CrPC, there was no provision that accused could be heard in case of complaint. But now the accused is also given an opportunity of being heard, and only then the magistrate could decide whether cognizance could be taken or not. Okay, and it is a very important provision in this aspect. So kindly underline it in the barracks and kindly highlight or mark it with a pen or a pencil that it is quite an important provision with context to any of the examinations, be it preliminary, mains, or interview. But it is quite a major change, and that is why you must keep this in mind. Now we'll talk about a new subsection which is added to section 223, and this is section 223 clause 2. And what does it encapsulate within its ambit? Section 223 clause 2 talks about that in case any complaint is made against a public servant, the magistrate cannot take cognizance until and unless two of uh, the requirements provided for under that subsection have been met. And what are those requirements? The very first one being that public servant must be provided an opportunity of hearing. So you see that the changes brought under this section are quite in the lines of principles of natural justice, right? And what is the second requirement? The second requirement is that the superior officer of such public servant will be asked to provide a report of that incident, and only after considering these two requirements, the magistrate will decide as to any future course of action. So now we are done with section 223 as well as chapter 16. Now we'll talk about chapter number 17, which deals with commencement of proceedings before magistrates. The very first provision where certain changes are brought forth is section 227 clause 1 proviso. So 227 clause 1 proviso talks about that provided that summons or warrants may also be issued through electronic means. So it merely is in lines with the very underlying principle included in the BNSS that more of the procedural aspects which could be completed electronically or via electronic means would be allowed to be done via those channels so as to facilitate effective and timely delivery of justice. All right. So in this context as well, issue of this section deals with issue of process, and the proviso provides that the summons or warrants may also be issued through electronic means. So the next section in our discussion is section 229, which talks about special summons in cases of petty offences. All right. The only change from our point of view in this regard is that the amount of fine in case of petty offences, which was earlier rupees 1000, has now been increased to rupees 5000. So in section 229 clause 1 proviso, you will see that it is provided that the amount of the fine specified in such summons shall not exceed 5000 rupees. And similarly, in section 229 clause 2, where petty offences has been defined, it provides that for the purposes of this section, petty offence means any offence punishable only with fine not exceeding 5000 rupees. And then the rest of the section goes on. So for our considerations, the only difference in this section that has been brought forth is that the amount which earlier under CrPC was rupees 1000 has now been increased to rupees 5000. All right. So the next section is section 230, which talks about the supply to the accused of copies of police report and other documents. So this section coincides with section 207 of the CrPC. And earlier under CrPC, the copy of the police report, the FIR, statement recorded under section 161 CrPC, statement recorded under section 164 of CrPC, all these documents along with certain other relevant documents had to be provided to the accused. But when we come to BNSS, all these documents are not only to be provided to the accused, rather to the victim as well. All right. Uh, of course, the documents, the statements that are recorded, that were recorded in 161, it shall be provided under section 180, and the one those statements and confessions under 164 is now covered under section 183. And certain other relevant documents, all those documents are to be provided to the accused as well as the victim. And if we go through the body of this very section itself, you'll find a phrase there that, and in no case beyond 14 days from the date of production or appearance of the accused. All right. So all these documents have to be provided within a period of 14 days. And 14 days from when? 14 days from the date of production or appearance of the accused. All right. So this is the major alteration that is brought under this section. But before we move on to the next section, kindly go through the second and the third proviso of this very section itself. The second proviso, you'll note that under second proviso, a phrase has been used: may furnish the copies through electronic means. So all these documents that we have talked of earlier, these could be provided under electronic mode as well. And the third proviso goes as, provided also that the supply of documents in electronic form shall be considered as duly furnished. So merely the fact that these documents have been provided in electronic mode does not make it questionable. All right. So even if the documents are provided electronically, then they shall be considered to have been duly furnished there, and it shall not be within the ambit of questionable procedure. All right. So with that, I believe we are done with section 230. All right. Now let us see section 231. 231 talks about the supply of copies of statements and documents to the accused in other cases triable by the court of session. Here, not a very major change has been made, rather a very small and kind of a cosmetic change has been made. You'll see that a word forthwith has been used in this section, that the magistrate shall forthwith furnish to the accused free of cost a copy of each of the following. So the word forthwith has been used, but if we talk about CrPC, in place of this word forthwith, the phrase which was used was without delay. So without delay is now substituted with the word forthwith, and I believe that the object behind such alteration could be to create a sense of urgency in that regard. All right. So that is all about the change that is brought in section 231. Now let us move on to section 232, which talks about the commitment of cases to the court of session when offenses exclusively triable by it. All right. So a very prominent change that has been brought here is that time limit yet again has been introduced under this section. Now all the acts which are to be done under this provision, that is the committal of the case, and beyond that sending all the records to the court, notifying the public prosecutor, etc. All these acts are to be completed and done within a period of 90 days. So time limit has been prescribed, that you cannot delay the committal of the case, you cannot delay sending of the report, you cannot delay informing the public prosecutor. All right. However, this period of 90 days is not a very watertight compartmentalization of this time period. Rather, this time period can be extended up to section 100 up to 180 days. All right. So these are the relevant time periods that have been introduced in the section 232. These are quite important and are to be noted and remembered. All right. Now Yet again, another change that is given under section 232 is under its second proviso. All right, the second proviso, if you go through it, you'll see that in the very last line, it goes as shall be forwarded to the court of sessions with the committal of the case. What shall be forwarded? If you see the second proviso, provided that any application filed before the magistrate by the accused or the victim or any person authorized by such person in a case triable by court of session shall be forwarded to the court of session with the committal of the case. So besides this committal of the case to the court of sessions, if any application has been filed by the victim or the accused or any other person authorized by such person in this regard, then all such applications shall be forwarded to the court of session all at once along with that committal itself. All right, so it is quite rational and comprehensible kind of alteration that we do not want to make the procedure technical. We do not want to make it time consuming. So for the ease of procedure, and so for procedural efficacy, all these applications are to be attached along with the committal itself. All right, and with this we are done with this chapter. Before we call it a day, we'll go through only one more change, and that change is under chapter number 18, the charge. Kindly open section 242, where you'll see that earlier it coincided with section 219 of CrPC, where the provision was that if within a span of 1 year, 3 offences of the same kind had been committed, then they could be clubbed together and they could be tried together. All right. The only difference that is brought under section 242 in this context is that earlier the number of offences was 3, and under BNSS the number of offences that could be clubbed together has been increased to 5, and that is all. With that, we come to a close for today's discussions, and from the next class we'll dive deep into the very important changes that are brought under the trial procedure itself. All right, so slowly but steadily, I believe that the changes brought under BNSS will be done soon enough. I again request each and every one of you to kindly note it down, mark it in the Bear Acts, go through all these changes time and time again. Believe it that it is a time consuming process, and it is not possible for anybody to comprehend the entire multitude of the change all at once. So you'll have to do it time and time again, and before you'll realize it, you'll notice that all these alterations are there in your mind, and you'll be able to effectively use it for getting the required results. All right, thank you.